Hey everyone, today we're going to answer the question, what is a patent search? Hi, I'm JD Houvener, a patent attorney and owner here at Bold Patents Law Firm. I'm also the author of Bold Ideas, the Inventor's Guide to Patents. I've helped over 10,000 inventors over my career in the past 10 years and helped to get almost 500 patents issued as of today. I'm excited to speak with you and talk with you about this topic of inventing and research, the patent search. Well, what does that term mean? And what should you be going toward if this is something you're considering doing? So a patent search, using that pure definition, means you're researching patents. I know that sounds overly simplistic, but it means you're looking at patents that have already, published, patents that have already been granted. And that's a great distinction, is that there are two different buckets of research. Those patents that have already been issued, right, going all the way back to, let's say, 1790. Okay, my goodness, anything, the common knowledge of what's been invented and patented before. And then there's the patent applications, patent publications. These are, published by the USPTO, the United States Patent and Trademark Office, or other patent offices around the world, and they're patent literature. I mean, their inventors filed them somewhere in the country, somewhere in the world, and they were seeking patent protection. And part of the process for that inventor, for that system, the patent system, is for it to publish, for you to share that knowledge with the world while you're trying to get a patent granted. And it might actually be you don't get the patent granted. And that's sort of that trade-off. Yeah, you're going to end up telling the whole world your invention while you're going through this process. And you're obviously hoping that you get the patent granted, but that doesn't always happen for a number of different reasons, whether it's the fact that your invention wasn't totally new or that it wasn't non-obvious, meaning there wasn't that much differentiation before, basically between your invention and what came before yours. So when you hire a firm or a patent agent, patent attorney, law firm to conduct a patent search for you, you're looking for results, right? Patents that have been already issued before, publications that have been issued, published before you file. Because if we find something that has been done before that's similar or exactly the same as your invention, you will not want to move forward. That's because if you did, the examiner, when they finally get to it, will just cite that patent that you had found or your firm found for you and say, sorry, this is not novel, this is not non-obvious, and we cannot award a patent for this. It's already been done before. So you can do some of that research on your own. Certainly there's lots of online resource tools. You can go to Google. Google Patents has its own page dedicated to patents. It's a great resource to start with. You can go to the World Intellectual Property Organization. They have their own search function as well. And last but not least, you have the Patent Center at the uspto.gov to conduct your own patent search. Now, not only patents, but non-patent literature is important too. So this is the second big area that you've got to search. And it's not always included when someone says patent search, unless you ask about it. So make sure you dig in and say, well, are you going to be looking for non-patent literature as well, non-patent publications? And the answer should be yes, because examiners can and will cite to non-patent documents. This is, for example, just information available online. Anything available online that's available to someone of ordinary skill in your art could go find it. And that's the type of data, information that's open. So you can just imagine, this is anything, any physical book, any online publication, any journal entry, right? Academic article. This could be something non-academic, right? Someone just out there selling their product on the free market. Then they chose not to move toward patent protection. If your invention, which you're claiming is yours, is too similar or exactly the same as what they've already done before, that would be a reference. That'd be a prior art reference rejecting your patent. And so you need to know what's out there both on the patent side and non-patent side. Now, on top of all of this, I know it's a lot of information. What you're really looking for is not just this giant list of here are all the patents, here are all the publications that you should consider, Mr. or Mrs. Inventor. You need, okay, what is my opinion? You need to know, should I file a patent application or not? Is what I've come up with unique, novel, and non-obvious? Should I move forward? That's a legal opinion. And so you need to work with a patent attorney to understand and appreciate that and to get that answer you're looking for to make a decision about how and when to go big or go bold. Okay? Well, hope this is educational for you. If you want to know more about patent search and your different options, I encourage you to click below. I've got the Bold Inventor Kit for you to take a look at. It has all your options, everything from free and doing it yourself to hiring a patent attorney. And there's a few options in between you should consider as well. So have a look at that. It also included the patent success matrix and your patent application options as well. Thanks for joining me today. My name is JD Houvener, patent attorney owner here at Bold Patents Law Firm. Have a great day. Go big, go bold.